we went on certiorari before the Honorable Supreme Court, raising this particular matter as an issue in our claim for grave abuse of discretion, justifying the resort to certiorari under the expanded jurisdiction of the Supreme Court, Your Honor. If this witness will be allowed to testify now, which is not scheduled, Your Honor, we are worried that our petition may be rendered moot and academic, Your Honor. So out of respect for the Supreme Court, Your Honor, we beg most respectfully that this be deferred even up to Tuesday, Your Honor.
Can you present another witness today with respect to Article 3?
Your Honor, for today, two witnesses were subpoenaed. And these are the bank officials. They are bank officials. It was scheduled by this honorable tribunal that they appear today, and I have information that they are here, and we want to present them, Your Honor.
No, it is in connection with impeachment number 3, Your Honor.
No. The only reason, Your Honor, if I may proceed, please.
Counsel for the defense, we cannot stop the process. With due respect to the Supreme Court, we are mandated to try and decide this case. The language of the Constitution is shall forthwith proceed with the trial and decision of this case. Now, you are free to state your objection on any question or against the presentation of these witnesses, but we will allow the presentation of the witnesses who are here now.
With your apologies to the Honorable Court, Your Honor, we went this far because of the statement on the part of Your Honor that we are not precluded to take any remedy in favor of the impeached public official under the rising sun.
That's correct.
So we did so, Your Honor, and we are not seeking a deferment, but merely because this is one of the issues that we wanted to raise, Your Honor, and we merely followed the suggestion of the Honorable Court. I do not think it will be a delay of the proceedings, a matter of 1 or 2 days, Your Honor. We are in total conformity and in full accord with the fact that this impeachment court is supreme on any matter relative to the trial, because that is enshrined under the Constitution, Your Honor. What we brought to the Honorable Supreme Court is the presence of what we call, with due apologies to the court, grave abuse of discretion in exercising the trial powers of this court, Your Honor. And the Supreme Court had acted on similar cases. For instance, the case of Francisco, Your Honor. What was questioned in there is the right to institute the impeachment proceedings. Supreme Court said, no question, it is the House of Representatives. But in the exercise of that power, although it is stated sole power to initiate, then we are empowered. It is our duty and power to inquire whether in the exercise of that power or authority there was grave abuse of discretion warranting the participation or the coming over of the Supreme Court, Your Honor. We do not mean to say, and it is our proposition, Your Honor, that this court has the power. That is undebatable. We submit to that. But in the exercise of that power, that must be in accordance with the Constitution, it must be in accordance with the laws and the rules of procedure. If the Supreme Court said there is no abuse of discretion, then we humbly submit, Your Honor. That is only our point, Your Honor.
Your Honor, please.
This presiding officer is in a quandary at the moment because there is no order from any authority to stop the proceedings of this court, and yet we are now being asked to stop it. What is the pleasure of the prosecution?
Yeah, we want to proceed, Your Honor. In fact, after the resolution last February 6, approving the request of the prosecution to issue subpoena to PS Bank and BPI, there was a motion to defer action of subpoena of banks from defense. It was ruled just now. So to us, there's no legal obstacle to proceed, and we want to present the witness, Your Honor.
I thought with the kind permission of the court. I thought we were discussing impeachment article number 3. That was we came here prepared
If
for
I
impeachment
may-
number 3. Your
If I
Honor.
may, Your Honor, please. Just a very short...
Supposing the Supreme Court came out with the pronouncement that the subpoena issued as against the bank officials and the production of those documents is not in accordance with law, Your Honor, what will happen with the proceedings here? Will it be considered null and void? Will it be considered valid, Your Honor, if it is the Supreme Court speaking on the issue already?
Your Honor, please. Your Honor, yesterday...
The prosecution.
Yeah, yesterday we presented, one of the prosecutors stood up and manifested that with reservation on Article 2, the first witness for Article 3 will be presented. But with reservation, the reason for that was we had request last week for issuance of subpoena to the banks, specifically the PS Bank, Katipunan Branch, and BPI. But that's the reason why we presented one witness for Article 3. But because last Monday, the tribunal decided and the witnesses were commanded to appear today. That's why we are now ready for Article 2. Your Honor, please.
In the absence of a TRO from the Supreme Court, the chair rules that we must proceed with the trial. So bring your witness.
Thank you so much, Your Honor. May we call on the branch manager or any duly authorized representative from PS Bank, Katipunan, Loyola Heights.
I only hope and pray, Your Honor, that the handling of the direct examination will be the chief legal prosecutor in this case, Your Honor. Just so we can have a good...
I will not bite that
so we
bait,
have
Your
a good
Honor.
encounter, Your Honor.
I will not bite that bait. And in connection with this, Your Honor, may we request that Attorney Demetrio Custodio, one of the private prosecutors, be recognized to conduct the direct examination.
Why not
Why not the chief
head of the panel?
Yes, the
Because
head of
we
the
are
panel.
because according to the presiding officer from the very beginning, we have the ground rules. And in the presentation of the witnesses, we may employ or engage the services of private counsel, Your Honor, please. And right now we want one of the prosecutors, Attorney Demetrio Custodio, to conduct direct examination for the prosecution.
All right.
Thank you.
Let counsels to Custodio handle the direct.
Good afternoon. Magandang hapon po, Mr. President. My name is Attorney Demetrio Custodio Jr. I would like to respectfully enter my appearance as one of the private prosecutors subject to the control of the public prosecutors of the House, Your Honor.
Proceed.
Thank you, Your Honor.
Let's wait for the witness.
Where is the witness?
We're calling. We're waiting for the witness.
May we beg the indulgence of the tribunal, Mr. President. The witness is being summoned.
Trial
Can we ask for
suspended.
a 1-minute suspension while the witness is...
Trial suspended for 1 minute.
1 long minute, Your Honor. So we can attend to personal necessity already. Pwede? Baka tawagin ulit. 1 long minute, Your Honor, to attend to personal. Okay. Thank you.
I will suspend the trial for 5 minutes.
5 minutes.
5 minuto pong sinuspinde ang trial, day 14 po ng paglilitis. Impeachment trial ni Chief Justice Renato Corona. Kanina, Gio, ay sana'y palalabasin na itong isa sa mga kontrobersyal na testigo ngayong araw na ito, branch manager ng PS Bank Katipunan, at siya sana ay i-direct examination ni Attorney Demetrio Custodio. Bago yan ay inattempt na harangin ng depensa itong pagpipresenta nitong witness, and si Justice Cuevas cited na merong petition na inihain ang depensa dito sa Supreme Court. Ito yung petition for certiorari dahil sa grave abuse of discretion daw nitong ng Senado in the exercise of power in trying the impeachment case against Chief Justice Corona. At meron pa nga siya mga kasong sinight. Bagamat pinayagan pa rin ni Senate President Juan Ponce Enrile, Presiding Officer Juan Ponce Enrile, itong pagpapalabas o pagpresenta nitong testimonya nitong branch manager ng PS Bank Katipunan.
At napasabi nga doon sa desisyon bago nagsabi ng agam-agam ang depensa na sinagot ni Senator Enrile na that the sole body that will try and decide cases when it comes to impeachment trial is the impeachment court itself. And sabi na nabanggit with the absence of the TRO, we should proceed with what is happening. And syempre, meron ditong reservations ang depensa na nasabi nga rin natin o na side interview nasabi ng isa sa mga defense lawyers na umaabot na daw tayo sa constitutional crisis dahil nagkakaroon ng standstill ang legislature at ang Supreme Court. So balit nagkaroon ng assertion na this is the impeachment court and the jurisdiction is on our side. And siguro yung putting the foot down of Senate President Juan Ponce Enrile is present again in this trial.
At bago yan, Gio, ay nagtapos itong cross-examination dito sa Pangulo ng FASAP na maraming mga mga technicalities na nabanggit at diyan natin kukonsultahin na nagbabalik itong ating legal expert, Attorney Joey. Ang tanong ko, sinabi, ilang beses na uulit itong final and executory decisions para po dun sa mga wala pang nagkakakaso at hindi pa dumudulog sa Korte Suprema. Ano po bang ibig sabihin pag sinabing final and executory ang desisyon?
Ang pinakasimpleng kahulugan nito ay yung desisyon ng Korte ay pwede nang i-implement, pwede nang i-enforce kung ano man ang desisyon ng Korte na naghusga tungkol dun sa kaso.
Attorney Joey, sa iyo bang pagkakaalam, meron bang mga instances wherein nare-reverse itong mga desisyon na final and executory na?
Meron naman. Dahil nga ayon naman sa ating rules of court, pwede namang maghain ang halimbawa, ang isang partidong natalo, pwede naman silang umapila o kaya maghain ng motion for reconsideration. Ito'y pinapayagan naman ayon sa ating mga batas. At meron din naman na halimbawa, natalo ka at dininay ang iyong motion for reconsideration in exceptional circumstances dahil nga kakaiba ang kaso at halimbawa, meron talagang dahilan ng korte para baguhin o kaya reviewin ulit ang kanilang desisyon, pinapayagan naman na magkaroon ng second motion for reconsideration. At mukhang ganito yung nangyari dito sa kaso ng FASAP. Kaya nagsampa ng pangalawang second MR na tinatawag ang PAL laban dun sa desisyon ukol sa kanilang kaso with FASAP.
Attorney Joey, nagkaroon ng mga tanong kung ano ba daw ang ibig sabihin ng administrative matter. Kasi AM daw ang participation ng administrative matter regarding the letters of Attorney Estelito Mendoza ang gustong talakayin o ang nag-take part ang Chief Justice. Ano pong ibig sabihin kapag administrative matter?
Sinasabing ito'y administrative matter lamang dahil yung division kung kanino na ka-raffle or kung kaninong may jurisdiction tungkol dito sa kaso ng motion for reconsideration ng mga unang desisyon ay parang nababahala sila na parang hindi sila dapat humawak ng itong kasong ito, no? So, iminungkahi nila sa Supreme Court sitting en banc. Ibig sabihin, yung buong Supreme Court ang umupo para magdesisyon kung anong dapat gawin sa pag-raffle nitong kaso, kung sino dapat ang division na hahawak. Kaya sinasabing administrative matter lamang ito ay dahil ang question dito ay sinong division ang dapat na hahawak nitong kasong ito. Lamang ang sinasabi ng prosecution mukhang kahit na administrative lamang ito, ang epekto nito ay mukhang nire-recall yung denial ng motion for second motion for reconsideration. At dahil merong recall ng second motion for reconsideration, ang sinasabi ng prosecution ay hindi natutuloy yung implementation or enforcement ng original decision na dapat ayon sa kanila final and executory na at dapat in-implement na. At dahil sa ganitong sitwasyon, ang sinasabi nila parang hindi nagiging simpleng administrative matter lamang itong kinalabasan ng sulat ni Attorney Estelito Mendoza.